Welcome to another edition of Question and Answer with a Criminal Defense Attorney. I'm Mark Solomon, a defense attorney in Denver, Colorado. And today's question, since the Derek Chauvin's defense attorneys and the prosecutors have filed sentencing memorandums 2 days ago, what is a sentencing memorandum? But before we get to that, don't forget to click like and subscribe if you're enjoying the videos and the little bell next to it to be notified of future videos. So today is June 4, and on June 2nd, both the prosecutor and the defense attorney in the Derek Chauvin trial filed sentencing memorandums for the judge to consider at the sentencing hearing on June 25, 2021. What does that mean? What is a sentencing memorandum? And the answer is a sentencing memorandum is something which gives the judge information on either points of law or fact or things that the judge should consider in making the judge's ultimate sentence in the case. They can argue, in this case, sentence enhancing factors. They can argue discretionary factors, whether the judge has to do something, whether the judge doesn't have to do something. And at the other end, the judge gets to make the decision about what he's going to do. All of these things become appeal issues because of the way the judge makes decisions on a final order. The way they do things, the law that's based on, all get scrutinized later on, especially in a case like this. So let's take a look at that webpage that the Minnesota Judicial Branch has started for the Derek Chauvin trial case. And you can see they have filed these attachment to the state memorandum of law and sentencing, also the state's memorandum on the law and sentencing. I'm going to get to that, what they actually said in just a minute. Also, the defense has filed post-verdict and sentencing memorandums to consider too. First off, what are they actually saying? And the answer is not surprising. First off, they both tend to agree that the presumptive sentence in this case is 128 to 180 months. That's basically 5 to 10 years. The prosecutor is saying that because of the sentence enhancing factors, of which he claims 4 exist, allow the judge to have an upward departure from that presumptive range to a maximum of 360 months, 30 years, and that's what the prosecutor in this case is asking for. On the other side, you've got the defense attorney, Eric Nelson, who is saying that's not mandatory and that sentencing guidelines are there for the sole purpose of allowing the judge to make a decision based on the facts in the case, the defendant, the victims, everything. And in this particular case, that defense attorney is saying that although the sentencing range might allow the judge to do an upward departure, he is not required to do so, and is therefore asking that the defense is asking the judge to give a sentence in the presumptive range, which is 5 to 10 years, not as much as 30 as the prosecutor is asking for. That was a question from one of our viewers. We want to thank him very much. It was a great question. He alerted me to the idea that these sentencing memos were filed. I'd missed that. So thank you very much. Keep that information coming. And with that, that is the question and answer for today. If you would like your own question answered in a future video, you can always put them in the comments below, tag me on Twitter, or email me. And as always, you have a right to remain silent. If a police officer asks you questions about who you are, what you're doing, what you have, or anything, you have a right to say, I don't want to talk to you. And if they persist, I want a lawyer. Thanks for watching. Keep those questions coming.